Hi everyone, and welcome to TS Fibro. If you haven't subscribed already, hit that subscribe button and hit the notification bell to notify you when I put out new videos. And if you like it, hit that thumbs up. And if you don't, hit that thumbs down. And if you want to, leave me a message below and tell me what you did like or don't like. Today's video is going to be on filing for disability, Social Security disability. People suffering from fibromyalgia suffer from chronic pain, debilitating migraines, and can have temporary issues with memory as well. Between all these symptoms combined, people with fibromyalgia may find themselves unable to find consistent work, forced to take sporadic leaves of absence for medical reasons, or just find it difficult to find a job they are capable of performing in spite of their condition. Fortunately, the Social Security Administration offers disability coverage to those individuals deemed to have a disability that prevents them from working. While this coverage is available, fibromyalgia cases can be very difficult to win. This is in part due to fibromyalgia being a sort of, if everything else fails, diagnosis. It is essentially the diagnosis one would get once all other causes for the symptoms have been ruled out. This makes fibromyalgia not only very hard to diagnose, but also just as hard to prove when making a disability claim. Being thorough, organized, and taking necessary steps prior to filing your claim may not guarantee success, but it will greatly increase your chances of being awarded disability benefits. There are a lot of steps to take in preparing your case, but the first step is the most important. Get your diagnosis. It may seem like common sense, but without a diagnosis, you have no case. Due to the nature of the disease, getting a fibromyalgia diagnosis can be difficult, as it requires doctors to rule out any other possible underlying conditions that may cause your symptoms. Once you have a diagnosis, it's time to look into the condition a little deeper. See a specialist. If your doctor made your initial diagnosis, or if their tests were simply inconclusive, you will want to get a referral to speak with a specialist, such as a rheumatologist or a neurologist, who has more experience treating and diagnosing conditions such as fibromyalgia. What if you can't get a diagnosis? If your normal doctor isn't giving you the support you need and is simply treating your symptoms and making no progress towards a diagnosis, then it's time to seek out a second opinion. Getting a diagnosis is essential for filing a disability claim, and you also deserve to get proper treatment for your condition. Gather your records. The next step is to gather all your medical records. Be sure to include the initial diagnosis in those records as well, even if it isn't the most detailed account of the condition. That record will give the Social Security Administration a timeline as to when the condition was confirmed with a positive diagnosis. Make sure you include records detailing treatment as well. If your records don't accurately portray your condition or are unclear, seek out a doctor who can more clearly articulate and document your condition. Filling out your RFC, residential functional capacity. That's what it means. Having your doctor fill out a fibromyalgia residential functional capacity, RFC, will help detail clearly and sufficiently how the condition affects your day-to-day life. Fill the form out with your doctor and make sure that the form specifies how the condition limits you physically and mentally, as well as impairs or prevents your ability to work. Now, gather non-medical evidence. You should also gather any other evidence of your condition, be it a diary that documented your day-to-day issues and struggles with the condition, testimonials from relatives, friends, family, and work records that show gaps in the employment or leaves of absence sufficiently due to the condition. This will help paint a broader picture outside of just the medical records. The Social Security Administration usually requests a record of employment showing any leaves of absence due to the condition at some point in the application process. So having this documentation early will save you some time. Should you get an attorney? The short answer is yes, though it's not mandatory. Having an attorney will help you navigate the claims process, and the attorney will be able to help you evaluate the strength of your case and help you find information to include to help strengthen your claim. An attorney can also assist with the appeals process if you get denied, since you only have 60 days from the day of the notice of denial to file an appeal. It's helpful to already have an attorney on retainer if and when you reach that point. How do you get an attorney? Retaining an attorney is a fairly simple process. It's mostly just taking a little research. The best way to find a good disability attorney is to ask your friends or relatives or any other attorney you may know who might be able to refer you to someone. If you can't get a referral that way, look up a local bar association online and reach out to them. They should be able to provide you with a number of disability attorneys who can assist you. I would suggest being careful about the advertisements you see on TV, and they'll say they do Social Security disability, but you want an attorney that specializes in it and doesn't do 500 other things. You want an attorney that specializes in Social Security disability claims. Go in for a consultation. The best thing about most disability attorneys is that they work off of a contingent fee basis, meaning they only get paid if they win your case. The consultation is free, and it's a good way for both of you and the attorney to fill each other out. You should ask questions and get as much information as you can, including how long the claim process will take, what additional records the attorney may need, how much their fees are if they do win your case, and how many similar cases have they been successful within their career. This will give you an idea of this attorney is a good fit for you. Make a decision. From here, it's up to you if you want to retain an attorney for filing the claim. You don't have to. My advice is you need to. Having a disability attorney assisting with the claim greatly increases your chances of success, as they know their way around the Social Security Administration claim process, as well as access to resources that you as an individual might not. They can also help with the appeals process if it comes to that. Can you file your claim now? With all the information and medical records on hand, make sure you have all of them. It's finally time to file your disability claim. You can apply in a number of different ways. You can either apply online, over the phone, or in person at your local Social Security Administration office. When applying, be sure to have all your medical records, Social Security number, contact information, medical provider information, and employment history, and any available tax information that you have. Now what do? Now comes the easiest part, but the most stressful part. Now you wait. You wait for Social Security Administration to review your documents and make a decision on your claim. This can be a lengthy process, taking from 3 to 5 months. During this process, the Social Security Administration will review all your documentation to confirm that your condition falls under their definition of disability. According to the Social Security Administration's definitions, you can be considered to have an applicable disability if you are working, you make less than $1,220 per month, if your condition is severe, limiting your physical and mental abilities for at least 12 months. If your condition is found on the list of disabling conditions, if you cannot do the work you did previously, if you are unable to do any other kind of work. The Social Security Administration may occasionally request additional information from you, like work records, additional medical records, or other documents. Just make sure you have everything. Okay, you filed for disability, got all your paperwork, got all your medical records, and you win the case. Congratulations. All that is left to do is accept your disability benefits, and depending on your preferred payment method, you may need to provide some banking information such as account and routing numbers for things for direct deposit. What if you lost your case? If you lost your case, there's still hope. If you haven't already retained an attorney, retain one as soon as possible and have them assist with preparing your claim for your appeals process. If you only have 60 days from the date you're denied to file an appeal, so don't forget that. So you're on a bit of a strict time limit. You'll also want to make sure your attorney has enough time to properly prepare your appeal. So notify them of your denial as soon as it comes in so they can begin working on it for you. When filing for an appeal, just like your initial claim, you can file online, over the phone, or in person. I personally had to file an appeal, and then I had to go before the judge. So you still have steps. Don't get discouraged if you get denied the first time, because probably 90% of people get denied the first time. It's probably a higher percent than that, but most people get denied the first time. I think Social Security hopes you'll go away. They won't have to put out any money. But don't give up. There's always other things you can do. Okay, with the appeals. What is involved with an appeal? There are generally 4 levels to an appeal process. The first stage is a reconsideration of the claim by someone not involved in the original claim process. You can present any new evidence for consideration at this stage as well. So if you have any, make sure your attorney gets it. If you disagree with the results of the review, you can request a hearing by an administrative judge. The judge will review all the evidence, question any witness, as well as rely on medical experts you present. Be expected to testify to your own experiences, but also be advised you are allowed to question those called to the stand as well. It's highly advisable to have an attorney if you plan on taking the appeals process to this level. Definitely have an attorney. If you disagree with the results of the hearing, you can have it reviewed by the appeal counsel. The appeals counsel will review the claim and subsequently the hearing and make a decision. If they agree with the initial ruling, you will be notified by letter of denial. The final step in this process is to have the appeal be heard by filing a suit to have the case taken to federal court. If you are trying to appeal at this level, an attorney is almost necessary for any chance of success. I advise you to get an attorney right away. Make sure you get an attorney that is experienced in disabilities, and don't go by one of these advertisements on TV. Okay, now, is there anything else you should know? While this is a very long process of preparing documents and filling out forms, it's important to get it done and submitted as early as possible once you've been diagnosed. The reason for this is that the Social Security Administration will backdate payment on your claim to the date you applied, but cannot backdate it any further. To ensure you are getting the most money out of your claim, file early. You will also want to see a doctor regularly in order to improve your chances of getting approved. Getting continued treatment and routine checkups show that you need continual treatment for your condition, and long gaps between doctor visits may indicate the condition is not as severe enough to warrant disability coverage. Doctors are also more inclined to cooperate if you are seeing them on a consistent basis. No matter how frustrating the process gets, or if your case is mishandled, try to remain cordial with the Social Security Administration employees or individuals representing you. These people can have multiple cases to handle and hundreds of phone calls to make on a daily basis, and being rude or taking out your frustrations on them may just end up moving your case to the bottom of their to-do list. It's always better to be nice. Lastly, don't call the toll-free numbers for updates. The toll-free number is more for general inquiries and assistance with the filing process, and they generally won't have enough detailed information about your specific case to be familiar enough to give you an adequate information. Other than medical conditions, what else do you need to qualify for Social Security disability? To qualify for Social Security disability benefits, you must first have worked in jobs covered by Social Security. Then you must have a medical condition that meets Social Security's definitions. In general, we pay monthly benefits to people who are unable to work for a year or more because of a disability. Benefits usually continue until you are able to go to work again on a regular basis. There are also a number of special rules called work incentives that provide continual benefits and health care coverage to help you make that transition back to work. If you are receiving Social Security disability benefits when you reach full retirement age, your disability benefits convert to your retirement benefits, but the amount remains the same. In addition to meeting our definition of disability, your medical reasons, you must have worked long enough and recently enough under Social Security to qualify for disability benefits. Social Security work credits are based on your total yearly wages or self-employment income. You can earn up to 4 credits each year. The amount needed for a work credit changes from year to year. In 2019, for example, you earn 1 credit for each $1,360 in wages or self-employment income. When you've earned $5,440, you've earned your 4 credits for the year. You qualify for Social Security benefits by earning Social Security credits when you work in a job and pay Social Security taxes. They base Social Security credits on the amount of your earnings. They use your earnings and work history to determine your eligibility for retirement or disability benefits, or your family's eligibility for survivor's benefits when you die. In 2020, you receive 1 credit for each $1,410 of earnings, up to the maximum of 4 credits per year. Each year, the amount of earnings needed for credit goes up slightly as average earnings level increase. The credits you earn remain on your Social Security record even if you change jobs or have no earnings for a while. Special rules for some jobs. Special rules for earning Social Security coverage apply to certain types of work. If you are self-employed, you earn Social Security credits the same way employees do, 1 credit for each $1,410 in net earnings, but no more than 4 credits per year. Special rules apply if you have net annual earnings of less than $400. If you are in the military, you earn Social Security credits the same way civilian employees do. You may also get additional earnings credits under certain conditions. They also have special rules about how you earn credits for other kinds of work, like domestic work, farm work, or work for a church or church-controlled organization that does not pay Social Security taxes. How long you must work to qualify for Social Security. The number of credits you need to be eligible for benefits depends on your age and the type of benefit. Disability. How many credits you need for disability benefits depends on how old you are when you become disabled. If you become disabled before age 24, you generally need 1.5 years of work, which is 6 credits, in the 3 years before you became disabled. If you are 24 through 30, you generally need credits for half of the time between age 21 and the time you became disabled. If you are disabled at age 31 or older, you generally need at least 20 credits in the 10 years immediately before you became disabled. Here's some examples of how many credits you would need if you became disabled at various selected ages. This does not cover all situations. It's just in general. If you are disabled from 31 through 42, you need 20 credits or 5 years of work. Age 44, you would need 22 credits, 5.5 years of work. Age 46, you would need 24 credits or 6 years of work. 48, you'd need 26 credits and 6.5 years of work. Age 50, 28 credits, 7 years of work. 52, 30 credits, 7.5 years of work. 54, 32 credits, 8 years of work. 56, 34 credits, 8.5 years of work. 58, 36 credits, 9 years of work. Age 60, 38 credits, 9.5 years of work. 62 or older, 40 credits, 10 years of work. When a person who has worked and paid in Social Security taxes died, certain members of the family may be eligible for survivor's benefits. Up to 10 years of work is required to be eligible for benefits, depending on the person's age at the time of death. Survivors of very young workers may be eligible if the deceased worker was employed for 1.5 years during the 3 years before his death or her death. Disability evaluation under Social Security. Here's some listing of impairments that contain medical criteria that apply to the evaluation of impairments in adults ages 18 and over, and that may apply to the evaluation of impairments in children under the age of 18 if the disease processes have a similar effect on adults and younger children. Musculoskeletal system, which would be covered under fibromyalgia. Special senses and speech, respiratory disorders, cardiovascular system, which is the heart, digestive system, genitourinary disorders, which is genital and urinary organs, hematological disorders, which is blood, skin disorders, endocrine disorders, which is a birth defect, congenital disorders that affect multiple body symptoms, neurological disorders, which could also fall under fibromyalgia, mental disorders, and malignant cancer, immune system disorders, which some of doctors are saying immune system disorders, that fibromyalgia can be filed under those, but I'm not real sure about that one. Evidentiary requirements. Medical evidence. Medical evidence is the cornerstone of the disability determination under both Title II and Title XVI programs. Each person who files a disability claim is responsible for providing medical evidence showing he or she has an impairment or impairments and the severity of the impairment or impairments. However, the Social Security Administration, SSA, with the claimant's permission, will help the claimant get medical evidence from his or her own medical sources or have evaluated, examined, or treated the claimant for his or her impairment or impairments. SSA also requests copies of medical evidence from hospitals, clinics, or other health facilities when appropriate. Claimants who provide SSA with timely, accurate, and complete information and evidence can help accelerate the processing of their claims. Existence of an impairment. By law, SSA needs specific medical evidence to establish that a claimant has an impairment. SSA regulations require objective medical evidence from an acceptable medical source to establish that a claimant has a medically determined impairment. The regulations define these terms. The severity of the impairment. Once the existence of an impairment is established, SSA considers all evidence from all medical and non-medical sources to assess the extent to which a claimant's impairment or impairments affect his or her ability to function in a work setting, or in the case of a child, the ability to function compared to that of children the same age who do not have impairments. Non-medical sources include, but are not limited to, the claimant, educational personnel, public and private social welfare agencies personnel, family members, caregivers, friends, neighbors, employers, and clergy. Claimant's responsibility. A claimant must inform SSA about or submit all evidence known to him or her that relates to whether or not he or she is blind or disabled. This duty is ongoing and requires the claimant to disclose any additional related evidence about which he or she becomes aware of throughout the administrative review process. The evidence must be complete and detailed enough for SSA to determine the nature and severity of the claimant's impairment or impairments, how long the claimant has experienced the impairment or impairments, and whether the claimant can still do work-related physical and mental activities with the impairments. Consultative examinations. If the evidence provided by the claimant's own medical sources is inadequate to determine if he or she is disabled, additional medical information may be sought by recontacting the medical source for additional information or clarification, or by arranging for a consultative examination. Generally, a claimant's own medical source or sources is the preferred source to perform the needed examination or test, and SSA will pay the authorized fee for the CE. However, SSA may use an independent medical source other than the claimant's own medical source to conduct the CE in several situations, such as the claimant's own medical sources prefer not to perform the examination, the claimant's own medical sources does not have the equipment to provide the specific data needed, there are conflicts or inconsistencies in the file that cannot be resolved by going back to the claimant's own medical sources, the claimant prefers another source and has good reason for doing so. SSA knows from prior experience that the claimant's own medical sources may not be a productive source, or the claimant's own medical sources is not qualified as defined by regulations. Consultative examination report content. A complete CE report will involve all the elements of a standard examination in the applicable medical specialty and should include the following elements: the claimant's major or chief complaint or complaints, a detailed description within the area of specialty of the examination of the history of the major complaint or complaints, a description and disposition of pertinent positive and negative detailed findings based on the history, examination, and laboratory test related to the major complaint or complaints, and any other abnormalities or lack thereof reported or found during examination or laboratory testing. Results of laboratory and other tests, for example, x-rays, performed according to the requirements stated in the listing of impairments. The diagnosis and prognosis for the claimant's impairment or impairments. The claims for adults, a statement about what a claimant can still do despite his or her impairment or impairments, and whether the claimant has one or more impairment-related limitations or restrictions in the following abilities. The ability to perform physical demands of work activities such as sitting, standing, walking, lifting, carrying, pushing, pulling, or other physical functions, including manipulative or postural functions such as reading, handling, stooping, or crouching. The ability to perform mental demands of work activities such as understanding, remembering, maintaining concentration, persistence or pace, carrying out instructions, or responding appropriately to supervision, co-workers, or work pressures in a work setting. The ability to perform other demands of work, such as seeing, hearing, or using other senses, and the ability to adapt to environmental conditions such as temperature extremes or fumes. In claims for children under age 18, a statement about the child's impairment, related limitations and restrictions in acquiring and using information, attending and completing tasks, interacting and relating with others, moving about and manipulating objects, caring for yourself, and health and physical well-being, and the consultant's consideration and some explanation or comment on the claimant's major complaint or complaints and any other abnormalities found during the history and examination or reported from the laboratory test, the history, examination, evaluation of laboratory test results, and conclusion will represent the information provided by the consultant who signs the report. Evidence relating to symptoms. In developing evidence of the effects of symptoms such as pain, shortness of breath, or fatigue on a claimant's ability to function, SSA investigates all avenues presented that relate to the complaints. These include evidence about the claimant's daily activities, the location, duration, frequency, and intensity of pain or other symptom, precipitating and aggravating factors, the type, dosage, effectiveness, and side effects of any medication, treatments other than medications for the relief of pain or other symptoms, any measures the claimant uses or has used to relieve pain or other symptoms, and other factors concerning the claimant's functional limitations due to pain or other symptoms. In assessing the claimant's pain or other symptoms, SSA considers all of the above-mentioned factors. It is important that the medical sources address these factors in the reports they provide. Listing of impairments. The listing of impairments describes, for each major body system, impairments considered severe enough to prevent an individual from doing any gainful activity, or in the case of children under the age of 18 applying for SSI, severe enough to cause marked and severe functional limitations. Most of the listed impairments are permanent or expected to result in death, or the listing includes a specific statement of duration. For all other listings, the evidence must show that the impairment has lasted or is expected to last for a continuous period of at least 12 months. The criteria in the listing of impairments are applicable to evaluation of claims for disability benefits under the Social Security Disability Insurance Program or payments under the SSI program. Listing of impairments contains medical criteria that apply to the evaluation of impairments in adults age 18 and over. The medical criteria may also be applied in evaluating impairments in children under age 18 if the disease processes have a similar effect on adults and younger children. The criteria in the listing of impairments apply only to one step of the multi-step sequential evaluation process. At that step, the presence of an impairment that meets the criteria in the listing of impairments, or that is of equal severity, is usually sufficient to establish that an individual who is not working is disabled. However, the absence of a listing level impairment does not mean the individual is not disabled. Rather, it merely requires the adjudicator to move on to the next step of the process and apply other rules in order to resolve the issue of disability. Listing of impairments, childhood listings. The following contains medical criteria that apply only to the evaluation of impairments in children under the age of 18. Low birth weight and failure to thrive. Musculoskeletal system. Special senses and speech. Respiratory disorders. Cardiovascular system. Digestive system. Genitourinary disorders, hematological disorders, skin disorders, endocrine disorders, congenital disorders that affect multiple body systems, neurological disorders, mental disorders, malignant cancer, immune system disorders. Okay, so now we've gone over everything you need to qualify for Social Security disability. In my opinion, I would get a copy of all my medical records. You can go to your doctor's office and ask them, or call them and ask them for a copy of your medical records. Most doctor's offices will charge you for a copy, but it'll be worth it because you're going to need names, addresses, phone numbers of all the doctors you've seen, any specialists you've seen, any tests you've had run, MRI, CT scan, whatever it may be, you're going to need it with dates and times. And if you have fibromyalgia, of course you're going to forget stuff because that's just part of it. So if you have it all in front of you, then you won't miss something that may cause you a delay in your disability. So that first application is very important to get it right, because if you do like I did and you just get online and you file and you don't have all this and you're scrambling around your house to find, names and addresses and you forget stuff and it's not on there, then it'll take longer. And it took me 2.5 years. And I had to go before an appeals court and before the judge. So if you have I could have saved myself a lot of time if I would have just gone and got my copy of my doctor's records and specialist and the tests that I had to run. It'll help you out a whole lot. Also, you're going to need a list of your medications, the directions on your medications, and most important, side effects of your medications. Because side effects from your medications can play an important role getting disability or not. So make sure you list all side effects, because the side effects from a lot of medications can inhibit your ability to work also. So make sure you list them. Now, if you call an attorney before you file, which I suggest you do, and just talk to them, tell them what you're doing. And some attorneys will tell you to go ahead and file. And if you get denied, call them back and they'll take it from there. So don't get discouraged. More than likely, you're going to get denied the first time. So don't get discouraged if you have to go for an appeal. If you get turned down for an appeal, then you'll go before the judge. But don't give up. make sure you call an attorney. And they won't charge you unless they win, and then they only get a percentage. But you'll have to ask the attorney what that percentage is. Good luck, everyone. I hope this video helped in preparing for filing for disability. I hope you get it. I pray for you out there because I know how hard it is to live with fibromyalgia, especially with people who don't believe in fibromyalgia. So good luck, everyone. Thank you so much for listening to my video. Please don't forget to subscribe, hit that like button, and hit that notification bell for me. Thank you, everyone, and good luck, and God bless.